news and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause. Welcome to The Probable Cause. This is a podcast covering the criminal justice system in Allen County, Indiana, in northeastern Indiana, and often the state of Indiana. I'm Jamie Duffy, your host and a local journalist, and to my left is our co-host, Michael McAlexander. He is the Allen County prosecutor, and like I said, it wouldn't be the same if we didn't have him. Also presenting today is my right hand, a voice for the victim, sometimes my proofreader, and very good at navigating the legal system, which can be confusing, as we all know. She gained most of her knowledge after she lost her son to homicide, a gun homicide, almost 9 years ago. So welcome everybody, here we are. Now today we are going to be talking about Allen County's practice of keeping probation violators in jail on a no bond if they violate probation. It's not typically done in the surrounding counties. This is what defense attorneys have told me because they are itinerant. They go to all the other counties and ply their trade. So, counties like Huntington County will actually let you bond out or pay a bail if you have a probation violation. And so we wonder, why is that? And we've got Mike, so he's going to explain that. Now, first, the courts. As always, we love the courts. So this week we had a murder trial. I asked Mike if he would take that one because I wasn't able to cover it. I covered something else. First of all, his name was Raymond Washington. And at the time that this murder occurred, he was found guilty. He was only 16. So if you want to address any of that stuff, I appreciate it.
I can't say a whole lot about it other than the basic facts because he has not been sentenced yet. So the conviction isn't complete until that happens. So there are also co-defendants on that case. I think it's safe to say this was an issue among some girls and some photos and trying to get those photos off of a phone and with truly tragic consequences. It just seems so senseless for 16-year-olds to be running around with guns and doing things that end up getting somebody killed.
I totally agree with that, and I do remember this happened. I am almost sure I wrote up that probable cause, and the fact that she was shot, I believe, in the backyard. Well, this is what's really heartbreaking.
And then didn't she lay there for like 9 hours?
She did, because her mother didn't realize she was back there.
And then she was in the hospital for, I believe, 7 weeks before she died.
So that to me is just like, I would not be able to stop shedding tears with that. So.
And he's facing, after his conviction, there's a maximum of 60, the murder conviction, and there were some other charges, but it will kind of essentially come down to the murder, is a maximum of 65 years, and it also had the gun enhancement of 20 years. So for a 19-year-old to be facing up to 85 years is basically a life sentence.
It is a life sentence. It is what we call in Indiana a virtual life sentence, and we do have at least 4,000 people sitting in prison on these. And I just wish there was something we could do, because like you've often said, by the time somebody turns 50 years old, they're not the same person. Okay, so last week I was in the courtroom and I partially covered the trial for Derek Baker, who seems to have a lot of legal troubles, as has been something of a trend lately, according to at least one local prosecutor here in Allen County. Baker took the stand, or as I referred to it in my article, as probably his last stand. He was found guilty on all charges: burglary with a deadly weapon, a felony 2, level 3 robbery with bodily injury, level 3 burglary with bodily injury, misdemeanor false informing, and paraphernalia possession, and an extra charge for being a habitual offender, which a defense attorney told me can add up to 10 years, so I'm told. Now, I found the felony 2 confusing. That's why I want to run it by Mike, okay? Because the felony 2 with the deadly weapon turned out to be a shovel, which they showed in the courtroom. He didn't actually threaten anybody with it, but he had it when he walked upstairs. He found some people who he said, quote, he thought they were squatters. They probably didn't know what to do with him, and actually he did pepper spray. The first guy, actually he broke into the back door. So right there, you know, there's going to be a few charges. But I don't know that he actually ever used the red-handled shovel on anybody. It just looked scary, right? And also, we should say that the people who were living in that house, who obviously had a right to live in that house, probably didn't speak English so well. So they see this kind of burly crack cocaine addict walking in, admitted crack cocaine addict. He was never shy about telling everybody that he was, I mean, I think all of us, including possibly Judge David Zent, Prosecutor Jamie Groves, and his defense attorney, public defender Tyree Barfield, we were all kind of astounded at how matter of fact he was about this habit of his. So if he had used a shovel to physically hurt somebody, it probably would have been a battery. Mm-hmm. Okay, so just by having the shovel, that's why I don't understand it was a felony 2. Felony 2, which is 10 to 30 years and 17.5 years advisory. Now, like I said, he's got a lot of legal trouble, so I don't think any of this wrangling is going to, make any difference in his sentence, believe me. But all in all, I figured out if he maxed out on all his charges, he's facing 72 years. He's already 53 years old. Sentencing date for the burglary is October 10th, which is the same date for the hearing on another case. So this guy goes to the hospital, cuts his ankle monitor. That was in January of 2023. In March, he commits an armed robbery. This burglary with the red-handled shovel and the pepper spray was 3 weeks after that on April 11th. So anyway, I wanted to compare the level of violence in this case to the Pikes Pub 6, who on video piled on a male victim with their fists, and one guy actually took a chair, bashed the guy over the head with it. Violence was far greater, in my opinion, in the Pikes Pub case. However, those 6 people got a felony 5, which is only 1 to 6 years. They did get a criminal gang enhancement. They did get a felony 6 for criminal gang activity. Of course, that hasn't been adjudicated. Neither has the armed robbery that Derek Baker did on March 27th. So I know, Mike.
Did he have a weapon?
The armed robbery, yes. Yes, he had a gun, and he only got a felony 3. So this is the way my right hand and I talk.
Pub guy?
No, the Pikes Pub guys, no. They had, their weapons were their fists, and one of the guys picked up a chair in the video, and whomps a guy, I don't know where, it was on the back, on the head. I know he ended up going to the hospital. He had to go back to the hospital the next day. Is there anything you can say on these differing charges, Mike? Because people will sit there and go, oh, gee, I wonder.
Well, we have several.
It's because they had a weapon. That's
right.
what my guess is.
A lot of our statutes, battery as a level 5 can be, it can be battery to a pregnant woman as a level 5. Battery with a deadly weapon is a level 5. Battery causing serious bodily injury is a level 5.
That's it? Wow.
There's some other ones as well, but those are different ways you do it. Using a deadly weapon, though, can elevate the charge. Mm-hmm. So, and there's case law that shows that a deadly weapon is some instrument that can be used as a deadly weapon. It is not restricted to, I think we all think, a gun. What do you do with a gun? You might do target shooting, but most people think if you're using a gun, you're going to be hurting somebody or killing somebody. A kitchen knife can obviously be used in the kitchen,
And we have had cases with that.
but it can also be used as a weapon, and it has been used as a weapon. People are pretty good about that because they see the connection and how badly a knife can hurt you.
Well, that's what Christina Habegger used on her victim, was a kitchen knife.
Now, when we get into other things, and probably the easiest example, when my kid was 10 years old, I went and bought him a baseball bat.
Uh-oh.
Okay, what did I buy it for? So he could play baseball.
Yeah.
Now, if somebody picks up that same bat and as they're walking into my house to burglarize it, why did they pick up the bat? I don't think they're going to get into a baseball game all of a sudden. They are going to use it to threaten and intimidate the victims. And they may or may not use it on them.
Okay.
Similar to replace the bat with the gun. If you
Or
go
with a
into,
shovel.
Well, if you go into a house carrying a gun to burglarize it, to steal things, why do you have the gun? To intimidate and protect yourself so that the victims don't come after you. So it's how you use the item. Presumably, if I walk into your house carrying a shovel, unless I happen to be doing landscaping in your backyard, there's no holes to dig in your living room.
That's true.
So why am I bothering to carry a shovel? Because my intent is to use it as a deadly weapon, as an item to intimidate you and to get you to do what I want you to do.
Well, he told the jury that he used the shovel because he couldn't break in to the back door with a credit card. Now, I want to tell everybody here, you can watch all of this courtroom testimony on the probable cause if you go on YouTube or you go on our Facebook page, because I was there with cameras in the courtroom and I got Derek Baker on the stand, and I think you will find it, as I always say, very interesting. I don't want to put another adjective on there and mock the whole thing. But so now we have an explanation for that. He did use the shovel eventually to try and pry off the weather stripping, which he said was keeping him from getting in the house. And then he ended up having to use his shoulder. I don't think it must have been that great of a back door, but anyway, he used his shoulder, and he looked like he was a pretty strong guy. And anyway, somebody that wants to get high, needs a water source, as he said, they're going to do anything they can to get in. And that's what he did.
And apparently nobody told him that there were various outdoor spigots frequently on residential houses that have water coming out of them.
Well, also, he went to the Marathon gas station before that, he said. And
I believe they have a water supply as well.
They do. So, just the whole thing, and like I said, the jury is probably dumbfounded. They say a jury of your peers, but I can't even see how those were his peers, but, that's a whole nother right there. So anyway, the other thing that he got a felony 3 for was an armed robbery with a gun. To me, I don't know why that isn't a felony 2, because he placed the gun on the counter. There were 2 cashiers. He saw the one cashier start looking at her phone and picked up the gun and threatened her with it. And to me, that's terrifying. I've never had anybody do that, but you'd have to pick me up off the floor after something like that happened. He was at the Dollar General, which is like everything's a buck in there. But, even $5 is a lot to a drug addict, which he is an avowed drug addict. I'm not making accusations here. So to me, he got an armed robbery with a felony 3 when he had a handgun. So that's why I'm confused that the shovel, the burglary with a deadly weapon, which is a shovel, is somehow more dangerous than showing up to the Dollar General and pointing a gun right at a cashier.
I can't speak for the legislature on that. When they redid the code, I think those both used to be felonies under the code prior to 2014. But I am guessing the distinction is the invasion of the castle.
Mm-hmm.
The burglary is held at that stage to a higher standard. and we're more protective of people coming into our homes.
Well, I'll go along with that. That's a good explanation. He is supposed to be sentenced, as I said, October 10th. That's the same day they're going to have a hearing on this armed robbery case, which did happen 3 weeks prior in 2023. But he, that'll have to be adjudicated somehow. He also has another case in Grant County. So I will follow him just because I find he's an interesting character. And, like right out of a book, shall we say, I want to read you a couple of lines. There's 2 different probable causes here for Mr. Baker in Allen County. And I want to bring up the first one. This gives you an idea of what the police have to face out here. First one is from the armed robbery. The probable cause was written by Officer Kyra Woods. And she said that when they gave him the money, he got $100 or $200 from the cashiers. They put blue dye in it. So when they caught him, he had this blue dye on his hands. So then Detective Tague, which I'm assuming it means Larry Tague, pointed out the dye stains on the defendant's hands, fingers, and face. And the defendant tried to rub off the bluish white dye from his fingernails. I mean, he'd have to dye all over the place, The defendant advised he was using a spray paint dye as a torch to light his crack pipe. So he's always got an excuse, right? The defendant licked his hand and again kept trying to rub the dye off. Now, I mean, here he is caught not red-handed, but blue-handed, right? The defendant denied the robberies and argued that the stain was not from an exploding dye pack. So beware anybody out there trying to take money from a cashier and then they hand you the money. It could have this stuff in it. But this was my favorite line. The defendant advised he wasn't going to cooperate with anything that didn't guarantee him walking out of the police station today to go smoke crack. That's how hardened he is. All right, that was from Officer Kyra Woods. Now the other one, which is really beautiful, belongs in a novel. This one is from Officer R. McGillivray. I wish I knew what his first name was. I could guess, but I don't know. R can be a lot of first names. So remember when I said that he got pepper sprayed, that Derek Baker did pepper spray the individual who was living there. Who then ran down to the marathon to tell everybody, hey, I got pepper sprayed. This man broke into my house. He had a red handle shovel. Everything, I guess it probably in not the best English in the world. The police are out there trying to figure out what the heck has happened, but they start looking for the mace. And this is where they find it. This is beautiful. While searching the area for the pepper spray, mind you, they're on Wayne Trace, okay? Officer C. McBride observed a small pink cylinder canister with the markings mace on it in the middle of the road on Wayne Trace, just south of Eastway Drive, in the same direction the defendant had fled. All right, tell me you can't just picture that. That is beautiful. Thank you, Officer R. McGillivray, for that wonderful portrait of what went on. And like I said, it belongs in a novel. You don't know where really good writing is going to pop up. And there's one other thing I want to bring up before we get to probation violations. So Mike and I talked about this just before we came on. So we know that the Indiana Department of Correction owes Allen County a good $1 million or so. Because they're not moving the inmates fast enough down to the prison system. In fact, today, well, we don't have the figures from today, but the other day they were 96. 2 days ago, they were 96 people who are waiting to get transferred down to the Indiana Department of Correction, which means that Allen County taxpayers are paying for these individuals to stay there when they're supposed to be going to prison, where I don't know that anybody would ever want to go. I've got a couple more horror stories out of a prison. But anyway, now we have a new article from the Indiana Capitol Chronicle, which is just an excellent source for state news. They cover the state legislature. A lot of us have subscribed to this. It is free. You can make a donation. They really cover just literally everything. It turns out that the Indiana Department of Correction, the same group that owes Allen County $1.1 million, is now going to the state budget committee to ask for almost $16 million for prison upgrades linked to immigration agreement, which means that they have set aside somehow or other in this overcrowded prison system in Indiana 1,200 beds that will be used for ICE detainees. And there's no timeline, according to the spokeslady that I talked to by email. But it's just like they said they weren't going to ask for these upgrades. Now they are asking for these upgrades, but meanwhile, Allen County is not giving their money. Do you want to say anything about that, since you are the head of the local JRAC and the Allen County Community Corrections Advisory Board?
Well, I think it's particularly upsetting to us because of the jail lawsuit. This has gone up, I think, in recent weeks. It's been as high as 106 prisoners that have completed all of their court hearings in Allen County and have been ordered to be shipped to the Department of Corrections, and they're sitting here in our jail. And I think we talked about this last week, that if those people were in the Department of Corrections, as they should be, or at least say 85 to 90 of them, we would be well under our mandated number of people in the jail.
Mandated is 585.
Right, that's the...
Right, I'm not 100% sure.
I mean, we have 732 beds, I think it is, but the federal government believes you're at maximum capacity, as Troy Hirschberger pointed out last week, because you have people that have to be separated from each other, or are on a medical isolation, or isolated for bad behavior, whatever the case may be.
It's actually a huge amount that have to be kept separate. It's like over 200.
Yeah, so that would get us down much more in conformity with what those judicial mandates and recommendations are. Instead, it continues to put us at risk for a federal judge to come in and give us maximum numbers that would require us to release people that we don't think should be released.
Right.
So it is disturbing that if the state has the money to fund that, and I think we talked about this last week, they only pay even with the uptick in the daily payment that DOC is supposed to pay to local jails, it moved it from $37, $38 up to $42 or $44.
42 is what the sheriff said, yeah.
And supposedly what I read is the contract to house these people with the federal government, that the federal government will pay the state $85 per day for the ICE detainees. I'm fine with them doing it, but don't do it on the backs of local counties and people that should be in our Department of Corrections. If we have that capacity, don't tell us you can't process them.
You know what? I would love to know what Damon R. Lichty, the federal judge overseeing this lawsuit that was, let's see, was it 2021 when he decided that, yeah, we have to do something, which is now the reason why we're getting a new jail, which is probably not the worst idea. I'm for the new jail. I had my friendly felon tell me a couple days ago that he was in the lockup in the holding cell and sewage was coming out from the floor. Now, I don't know if that has anything to do with the construction around downtown, possibly, but I know that the plumbing there is just absolutely horrible. And so I do believe we need a new jail. But if they're asking the state budget committee for almost $16 million, then they need to pay their bills.
Well, and that's definitely the case. Supposedly they are going to pay what they owe the local. They just announced that yesterday or the day before.
Yes.
Certainly that's only fair, but most of those shouldn't be sitting in our jail anyways when we're under a federal court order to keep that population down.
I feel like, too, that the federal government is really shelling out a lot of money right now for this kind of incarceration, so that they're probably going to get paid back for that. And so they would be more than likely probably have the money to at least pay the county. So,
Well, it's hard not to look at it and wonder a little bit about some cost shifting that the state will make money at $85 a day. I know in the past, the Department of Corrections, this was probably 6-7 years ago, the Department of Corrections gave a number in the $55 a day range that it costs them to hold a prisoner on average. So even if that's gone up inflation-wise up to $60 or $65, they're still making a pretty good penny. And when they're only paying 42 or 44 to the locals, and then to not pay your bills is really insulting.
yeah, it is. So, come on, you guys. Give us that money. Allen County needs that $1.1 million. I'm sure that the county councilman, I'm sorry, there is a lady finally on that. They know what to do with that $1.1 million. All right, well, we've hashed this one out pretty well. All right, so let's go on to the no bond for probation violators. I looked at it today. I wrote it down. So where is my number for probation violators? Actually, we haven't gotten the new numbers, but probation violators, let me just see. I want to say it's 196. And then you would also have them for the circuit court violators, which is 12. Community corrections, which is 18. That's 30 more onto there. So we're about 215 probation violators from all sources. Defense attorney here believes people should be able to bond out, pay bail to be released. So that's the first thing on the table that apparently Allen County doesn't want to do.
Well, each county has their own rules, if you will. A bond schedule or the determination of bond is ultimately up to the local judges. And in Allen County, it's been the long time practice in our Superior Court is if somebody is in on a probation violation, they are held till their case is resolved. If it's due to so-called technical violations, which frequently are, if you're told you can't use drugs and you test dirty for the drugs, that's a technical violation.
That's a technical violation?
Mm-hmm. People like
I have examples of other ones here.
Not showing up for an appointment isn't committing a new crime. There's various things that you can do that would be considered a technical violation, any violation of your probation that is not a new crime. But usually the probation department isn't revoking people or filing a petition on it if it's a first-time offense kind of thing. They may, depending on the severity of it, take somebody before a judge and have the judge admonish them and remind them of the importance of the conditions of probation.
But I thought they always did that when there was a probation violation.
No, a lot of times the probation officer handles it.
I had no idea. So they have...
It's just like our problem.
And minor violations and like first violations. At least my experience with the people I know that have been on probation have been handled by the probation officer with community service or extra classes or whatnot. But I don't know what's the cutoff. 2, 3, how many probation violations do they have to get before they get remanded?
Well, so how are they? Are they still in jail with this kind of thing? They're not.
Not always.
Okay.
I mean, again, it depends on the severity of the violation. If somebody shows up 15 minutes late for an appointment, they may get a good talking to by the probation officer. Just like everywhere else in the system, a police officer, if they stop you for a traffic ticket, has certain discretion. Give you a warning, give you the ticket, don't give you the ticket.
Right.
Tell you, hey, slow it down, keep moving. Probation officers have discretion, just as prosecutors have discretion, just as judges have discretion. So, there isn't something that you hold on every case that this is going to result in a violation. But I would say that generally, and the other part of the subjectiveness on this is the probation officer is also doing an evaluation of who is this defendant?
Okay.
What is their education level? What is their, if you will, mental acuity? How
And responsibility.
yeah,
How many kids do they have?
Well, I would say mental acuity means sort of like IQ.
right. I mean, are they capable of
Low
understanding?
intelligence.
Sometimes we have people that, simply put, just aren't very smart.
Right.
And so all of that goes into the subjective part if the probation officer feels like, is this person doing their best? Or do they have the opposite attitude that they're essentially blowing off, yeah, you know, that's your idea, not mine. If they're running their own program, as we say. So there's,
Running their own program.
well, we have a lot of people that don't want to do what they're told.
Yeah. That's why they're probably in jail.
So by the time you get your probation, even before it's revoked, but to be put in jail for a technical violation, there's usually a pattern that is developed.
You're saying then it's not always just for the first one. Or say,
Yeah.
hey, I'm going to give you a second chance. It really depends. It's like the DCS, in my opinion. If you get an understanding, experienced, let's say, case manager in DCS, you might have a fairly good experience. But if you get somebody who's got a bitter turn to them, it could make your life miserable.
Well, you know, we see this.
Well, and I've seen situations where there just was a personality conflict
Oh, yes.
between the person on probation and the probation officer, and they, I mean, occasionally use their discretion in a bad way, in my opinion.
And
Are
there's,
you allowed to switch your probation officer?
I don't know what their appeal right is. They are given a certain type of caseload generally. I'm sure there's some ability to check on that, but it's like anything else. Some people are better people persons than others. I mean, we see that with police officers in doing interviews. Some people are better at it than others of gaining cooperation and trust.
But also you could get in trouble if you're a probation officer and the individual that you have a soft heart for, you know, you realize that they've had a traumatic childhood and all these reasons why they really just aren't doing very well in life, and then they go out and...
Everybody's goal in this process is to protect bad things from happening.
Right.
But everybody involved is also human. We can make bad calls. But I think everybody who stays in this business very long is there to try to help. And probation officers wouldn't be there if they didn't want to try to help these people do better.
I suppose they can get burned out too.
I'm sure they can.
I mean, when you hear like this one guy, he, you know, like I said, my buddy who's a felon, and he pulled a good whopper there on North Clinton Street the other night with, you know, public disorderly resisting and all of this. I just said, you can't stand there and call the cops names and yell at them. And, you know, even if you're like super drunk, this is not a smart way to behave. You know, I think he might have listened to me a little bit, but I don't know. A judge does hold the authority to decide whether to set a bond, and a probation violation indicates that the defendant has already broken the court's trust. All right? I said that probation is a privilege, not a constitutional right, like the initial presumption of innocence.
Right, you've already been convicted.
Right.
You're serving out a sentence. If you're on probation, that is an alternative to incarceration. So, you know, I think getting back to locally, if you commit a new crime while you're on probation, that's clearly a violation. And our local policy, for as long as I can remember, is to hold people that commit a new crime while on probation until they are either convicted of the new crime and then revoked on the first crime, or a determination is made that they didn't violate their probation or that they weren't guilty of the new charge.
So I'm wondering now that these other counties that do let people out on probation violations, is it just another way to collect money?
The
Yeah,
court,
we'll let you out, but that's going to cost you Lord knows how much money.
you know, each county kind of has their own system, and there's not a lot of uniformity. Some of them use a cash bail. When I was in law school, I was a bail commissioner in Marion County.
No kidding.
And one of the things that we did...
Just another little thing we didn't know about Mike McAlexander. Another little thing you may not remember is that he speaks Vietnamese. Please go ahead.
But Marion County at that time had a program that you could go through a surety, a private insurance company basically, on a bond. And that has traditionally been you put down 10% of what the bond is. So
Right.
if you have a $5,000 bond, you put down $500. But you then are making a contract with the surety, usually through an insurance policy, that you will show up for things and not do something to violate your bond. But Marion County in those days had a program that you could post money with the court. And what they usually did was look at the bond schedule and then only require 10%, that 10% be a cash bond that you would post with the court. And say in that situation, you had to post $500.
Right.
There would be an administrative fee that we would keep, that the courts would keep, that was like 10% of that.
Okay, so 50.
And if you went through and did everything you were supposed to, that other $450 would either go to help pay any fines you had, or any other court costs, or would be returned to you if you were found not guilty. And
That doesn't sound like such a big system.
and some counties, I think, do a combination of those. They may have you do a surety and a cash bond type of thing. So there's a lot of variations. I've heard a lot of things from some of the smaller counties. Here we are primarily we have a bond schedule. Most of the lower level misdemeanors are subject to release on your own recognizance, so that you don't have to post a bond. As you get into felonies, there is a bond that needs to be posted frequently.
Well, the OR, as they call it, released on your own recognizance, when did that get started in Allen County?
And we've had it, again, that's something that's been around forever.
Oh, okay.
So with that, you have all these different varieties of release. And in Allen County, when we started the pretrial release project back in 2016, 2017, one of the reforms we did, it used to be that a defendant would have to ask for a bond reduction. Otherwise, we went by the scale. Well, one of the things we did was everybody who comes in, whether they're arrested on a warrant and are being held pursuant to the bond schedule, or if they are arrested on a warrant that a judge has reviewed and found probable cause for. At their first hearing, if it's in felony court before Magistrate Kearns, he conducts a bond hearing. So everyone who's coming through is getting an evaluation.
I'd like to
if
go
they
to
haven't.
those again. I like going into Sam Kearns' courtroom.
Well, other than this week, he's there Monday through Friday.
Well, does he do bond hearings every day?
It's part of the initial hearing.
Right, okay.
So if they're still in custody, now a lot of people will go ahead and postpone because they don't want to spend the night or 2 nights or 3 nights or 4 nights before their initial hearing. They will postpone rather than waiting for that hearing. And the same thing in misdemeanor court. If
It's like lockup is pretty rough, let's face it.
Well, domestic violence cases are held till the first court appearance.
Yeah, no matter what.
Right. And that's something we've done for quite a while. The legislature passed something recently that I think requires a 24-hour hold.
So everybody can simmer down. Although, of course, my view on domestic violence sometimes is that, and I know this sounds strange coming from a woman, but I just feel like it's used as a weapon sometimes. Like sometimes there really is somebody getting hurt, and then sometimes I like wonder about it. You know, he's seeing another woman, and this is what's going to be my revenge. Well, wait a minute.
Like strangle their own selves and make marks on their necks.
You've known people who've done that?
Yeah, I've seen a girl do that.
Oh my God. See, there you go. She should be charged.
Well, if that can be proven, she would be.
Good. All right, so here I go to probation is a conditional release, and a violation demonstrates that the individual has failed to follow the rules of that conditional agreement. The judge must decide, this is the part I'm paying attention to here. The judge must decide if the person can be trusted to remain in the community, and a no bond hold prevents a repeat offense while they await a hearing. To me, that sounds like a presumption that that person's going to go out and commit another crime.
Well, if they're on probation.
It probably happens real often when the guy gets out of jail and he's mad, he goes and tries to rustle her feathers again.
Like this time, I'm really going to show her.
Well, that's been, I think, the justification for what's frequently referred to as a cooling off period.
Yeah, I think that's a good idea.
And that's where locally we do it at the initial hearing. But we do our initial hearings almost immediately compared to a lot of jurisdictions.
Really?
Yep.
You mean they sit there and make them wait?
Sometimes. You know, or they release them and give them a date quite a ways out for their initial hearing.
Yeah, except for, doesn't that depend on what they've done?
Yeah.
Right. So if they're caught on marijuana possession.
But we pretty much routinely.
Got to bring up marijuana every time we have a podcast, just for a joke, just to get him riled up. Just keep going.
If somebody is charged here in the Allen Superior Court with a felony or a misdemeanor, they will be brought up not the next day, but the day after that.
Right, I've kind of noticed that.
And when we changed our charging stuff to what I refer to as more direct filing right away, as opposed to using the 72-hour hold that we did for a long time. We were about the only county in the state that did that on a regular basis. It was very confusing to people because they'd get arrested, they'd go into court the next business day, they'd be told to come back 3 days later, and if
they'd be told that the charges were dismissed.
Well, because technically the charges were dismissed.
Right, but that's what was confusing to a lot of people. Like my charges were dismissed. Now there's a new thing on my case. Like some people would tell us like, oh, it was fraud and they illegally charged us because they dismissed the case, and people just really did not understand that process.
Nope, they didn't.
And I spent a lot of time explaining it, you know.
And
families were confused.
And so if it was a case that required additional investigation, or we needed some evidence that, like evidence of a prior conviction from another county or another state, or we needed blood evidence to be analyzed, we would dismiss the if you will, the temporary charge. And sometimes it was really fast. We might not, I mean, our standard arrest over the weekend, they were in court on Mondays, ordered to come back on Thursdays. They come back on Thursday, the case is dismissed. And if there was a delay in getting the new warrant out, they get arrested Thursday night or Friday morning. Other ones, it could be several months before the new charges were filed, or
So,
maybe
but when
they weren't.
went initially in front of the judge, were they released then? And the charges were dismissed?
When the charges were dismissed, yeah. And it was confusing, and especially, I think, if they did post bond, and then they got arrested 3 days later, it cost.
A deal, yeah.
Yeah, I mean, it was really an awkward situation.
Now, Mike, what happens now if you need more time to investigate?
We either don't file on the front end, or I think we've been more inclined to continue to gather evidence. If we reach a point where we don't think what we've got is right, we dismiss.
But that's what, with prejudice, or which one is where you can refile?
Without prejudice.
So they'd be dismissed without prejudice, which
Right,
allows
so-
you to refile when
Yes.
you get more evidence.
That's such a hard one to keep straight, with or without prejudice. So, another factor in all of this is the severity of the violation. We did touch upon that. The nature of the violation can influence the judge's decision. I think technical violations are the ones that kind of bother me the most. And here they've got failure to complete community service. So it's not, there's a professor out in California who keeps track of these things. I had a big long interview with her once. Who knows, maybe someday we'll get her on the, attend a meeting or pay fines can sometimes result in a bond being set. And I can remember in Sam Kern's courtroom once, there was this poor guy who had custody of his 1-year-old daughter. He lived with his uncle. He had no transportation. He worked at Mickey D's. His Mickey D's was across town. He was trying to get that changed, although franchise owners, you know, they don't always transfer. He owed $3,000 to community corrections. So, of course, Judge Kearns had to decide, first of all, was he telling the truth? You
Well,
know.
putting my community corrections hat on,
Yeah, please do.
we have not gone after people just for failure to pay fees.
But he was
We
ordered
have not
to
tried to
appear.
revoke on somebody just for fees. It's frequently listed as the 3rd count, the 5th count, the 8th count on a petition to revoke, but it's never count 1.
Well, my feeling in all of that too was when I heard him talk about it, because I was sitting there, you know, it must have been a couple of years ago. I wish I could find his name to find out how he's doing. I was just wondering, what, you know, this is going off the probation violation thing a little bit, is like, what can we do to help this man? You know, doesn't have a car. I don't know, maybe he wasn't even allowed to drive. I don't know why he was, you know, in the, you know, having a court hearing over his fines to begin with. I don't remember. But the technical violations, attending a meeting, paying fines, and then they get slapped in jail again.
Well, I would say in that situation, if he was doing everything else correctly, he was probably pretty chronic. It's like somebody who tests dirty. 1 or 2 dirty drops over the course of several months is not going to get a big sanction. It might at some point get you community service. And if you don't do the community service, we frequently use that in some of the problem-solving courts.
I just wondered, maybe that would be a good thing to just figure out what community service is sometimes. I do see the guys from the jail with the yellow jackets going around picking up trash, but I don't know what the community service is, because there again, transportation is a big problem.
Well, but it's given as a sanction, just as a weekend in jail is given sometimes as a sanction.
Yeah, you
But-
go spend a weekend in jail and then it's okay. Is that what you're saying?
Yeah, we've in a lot of the problem-solving courts, you use what we call intermediate sanctions to get somebody's attention, so that you don't kick them out of the program. You want them to. It's behavior modification. If they do something wrong, you punish them, but it's a punishment that is supposed to be commensurate with the crime. It's like a lot of this is like raising children. You know, you don't ground your teenager for a month because they were 5 minutes late on a curfew violation. You might tell them, okay, tomorrow night you have to stay home because you violated our trust. And a lot of probation is like raising kids. You try to make the punishment fit the crime. The more chronic the bad behavior is, the bigger the sanction is.
Yeah, it is such a problem, really. There's one thing here. It says, in Indiana, probation violators may not be held for more than 15 days without a hearing. An attorney can represent the probationer to argue for a bond at the hearing.
Okay.
Is that true?
Yeah.
In Allen County as well? Okay.
I mean, we bring up, if you get arrested for a probation violation, first, a judge has reviewed a petition that has been filed either by the prosecutor or the probation department alleging some level of bad behavior, whether it's so-called technical violations or whether it's a new crime. They will be brought up. If you look at the calendar, on Sam Kern's, the magistrate who does the arraignment calendar,
Mm-hmm.
The first group of cases he does are initial hearings on new cases. The second group he does on the calendar are initial hearings for petitions to revoke. So those are being put into court again within a day or two, usually, of the arrest.
Even with the drug court violations, does he hear those too, or does that go to drug court?
Usually that goes through drug court. Depending on if it's a new crime, they will probably appear in front of him before they have a hearing in drug court.
Okay. So you all well, I'll bring up Mr. Baker again, who's just doesn't care what you think about him. He wants to go get that high. I want you all to go read that story because I spent a lot of time writing it. Okay. Oh, now this is a really funny one because, I always go to Quora because that's where some of the funny stuff is. And this is one man who says your probation officer owns you until your probation period is completed. And how well do I know that from talking to some of the people? They think they're almost off of it and then they goof up, right? Like my buddy the other night. If you violate your probation, you can be sent to jail to complete your sentence. Your probation officer, we're going to call a PO, can simply put you back into the system. There is more leniency if you were sick, proof required. Or detained in a place where you could not call the office, proof required. This is like the Raven, proof required. All right, if you were hospitalized because you were unconscious.
I've got news for you. You don't just take the person's word. I mean, this is a variation on the dog ate my homework.
Exactly. Okay, so if you were hospitalized because you were unconscious or having surgery or in a coma, proof required. Mm-hmm. Your PO would make notes and show leniency. If you were attending the funeral of a parent, sibling, or grandparent, obit and proof of attendance required. You would be shown leniency. Now, here was where we go in a flight of fancy. If you were kidnapped by aliens and were on their ship, take pics. Get a note from the aliens.
Are you serious? Is that seriously?
This is from Quora. Of course there's aliens. We've discussed this. Get a note from the aliens and send both to your PO. Here's even a better one. If you were on your way to the PO's office when a pack of wolverines, Tasmanian devils, and rabid wild boars attacked you and you spent the afternoon fighting them off with only a toothbrush and a bouquet of petunias, take pics of your shredded jeans and legs, take pics of the 100+ sutures, and note from your emergency doctor, send the pics to your PO with a promise to arrive the next morning. But if you just fail to show up because you feel your PO is not the boss of you and nobody's going to tell you what to do, prepare for a lackluster reception when you do show up. you know, notwithstanding those Tasmanian devils, I mean, you got to have a laugh out of this, you know. In Indiana, people do tend to take things very, very seriously. And I can compare it to New York, New Jersey, and of course France and England. So this person asks, what if there's a warrant out for your arrest for violation of probation? Is it better to turn yourself in? Would there be less jail time for turning yourself in? The violation was not checking in on time and not meeting first violation. So I have this person's take. Do you want to say something first on that?
Well, my recommendation would be to turn yourself in. It's probably not a big surprise, but I think that would be taken into consideration, that you respected the authority of the court and recognize that you've messed up. On a practical basis for the individual, you're controlling a little bit of your destiny that way, as opposed to getting stopped for a tail light out and you've got your family in the car with you, and suddenly they've impounded your car and your kids are left at the roadway taken to foster care or something like that, and watch you get arrested. So there's a little bit pick your poison, control your destiny, show that you're taking responsibility.
I mean, I just wish that
And if it's on something like
happen.
that, that's a pretty minor violations, that's the type of thing that if you go in, you're probably much more likely going to be able to talk the judge and your probation officer into, you know, give me another chance. I understand you're serious about this. I'm sorry I messed up. Fall on your sword.
Yeah, I mean, especially if that, you know, that scenario, you just, but anyway, he says, this is this man's response, okay? And it's a little bit outré. People are quick to say how much better it is to turn yourself in. That's a load of crap. That's not how I talk. This is what this guy's saying. The time they calculate for a violation is what you sign when you get probation. It's statutory. It has nothing to do with whether or not the judge is in a good mood. In fact, it's much better for you to let a bunch of years pass. That way, when they catch you, or as they say in Indiana sometimes, catch you, you can say, hey, I'm 40 years old, I've been out of trouble for 20 years now. In a case like that, the judge just dismisses the whole thing. I was on paper, I reported to the PO the first day when I got out of jail, then I just bounced. So I've got a question on this one because it seems really wacky. Is there a national database system that might track this individual now? Like, let's say you bounced.
Well, I mean, there's a warrant system that we put, sheriff puts the warrants into the NCIC. So that's how you, when somebody gets stopped on a traffic violation in Florida and they discover they had a warrant in Indiana.
And can you just explain what NCIC is for people who
National
don't know?
Crime Information Center, I believe, is its.
Right.
So, yeah, there is a network for active warrants. And the only thing that it sometimes depends on the jurisdiction. Sometimes they'll let people out on warrants.
If they don't think they're a risk.
We have done certain things, like in child support when we can't find somebody and there are thousands of dollars in arrears. We might put out, file a criminal charge on them, hoping that they get stopped in Arizona or Texas or Georgia or wherever.
One of the warmer states.
Yeah, usually. That thing that he is referencing, I've had a handful of those, of people over 40 years,
Wow.
of people that absconded from probation and went 10, 15, 20 years without anything.
Did you dismiss it?
Sometimes. And under the theory that if the purpose of probation is to rehabilitate, well, somehow sounds like they managed to do it. It's not something that, but when you look at the number of people that are arrested for for having their probation revoked versus the number that are successful that way, it's probably about 1,000 to 1, if that.
Oh,
it may be more like 10,000 to 1. I think it's just a very, if you can't meet the basic requirements of probation, you're not a very responsible person, and you're probably going to get caught.
I see some people need a helping hand up. Like if the bus system here, God willing, they do try to provide buses. But if I come down Lima Road or wherever I am and I see those guys waiting at a bus stop, there's no shelter, and there's just, it's very sad. So here's another one, and this is an attorney. I've represented lots of clients in that position, probation violation. The strategy that seemed to do the best at damage control was for me to call the PO and say that I got a call from my client who screwed up and is scared to death about it and wants to get back on track. And no, there are no new crimes, and he's willing to take a UA. What would that be? I couldn't figure that one out. How would you prefer to deal with it? That always worked best with the probation officers with whom I had a decent working relationship. The parallel strategy in the absence of an attorney is for the probationer make exactly the same phone call to the PO, except cast it in first person. That may even be a better strategy depending on the probation officer. If this is a bench probation, the phone call goes to the probation judge, and the phone call needs to be made sooner rather than later.
I mean, I think, again, it's under that same theory of acknowledge it. And again, depending on what the level of violation is.
Absolutely.
Missing an appointment is one thing. They'll probably work with you, unless this is the 5th missed appointment you've done. But if it's the first one, definitely call up and say, I'm sorry.
But even if it was the 5th one, I still think they should call.
Is probably a better way to do it.
Right.
You know, I panicked. I thought you were going to arrest me, so I missed the next 2 appointments, kind of thing.
Yeah. I mean, that's great advice. And, you know, he is the Allen County prosecutor, so he's going to give you the best advice you can get without actually being your attorney. So anyway, we have been talking quite a while. Does anybody want the last word? As I always offer the last word.
Well, I just wanted to get to something that, one caveat here locally. It is my understanding that the Allen Circuit Court, which primarily handles drunk driving cases and habitual traffic violators, has been known in some circumstances to release somebody on a new bond for a probation violation. Superior Court, though, has stayed it's a pretty hard and fast rule. There may have been some over the years, but I think they would be very unique circumstances. And part of the reason for that is they've clearly violated something.
Right.
And by having that extra charge on them, it creates, even if they're relatively low risk, it's creating a great incentive for them to run. If they know, oh gee, I'm on probation for 2 years or 4 years. So and now I've got a new charge that's maybe another 2 years. If they give me 6 years, I don't want to do 6 years. I'd rather take my chance running. And that's the danger, that they've already shown that they weren't going to follow the rules. So I think their level of non-compliance and the failure to appear rate would skyrocket if we let people out on probation violations.
And we've already covered failure to appear. And it's not
especially if you have a new charge hanging over your head, because that's going to go, by statute, be a consecutive sentence to your probation violation.
Oh, by statute, that's consecutive, which means you have to serve one and then the next. You don't serve them at the same time, which just makes your life that much more complicated and away from your family.
Think of it as if you're on probation for a theft, and then you get caught with meth or cocaine. So maybe they're both level 6 felonies, but suddenly piled on top of each other, that could be as high as 5 years total. And that could spark somebody to want to run. And that's a theory behind our reason for holding people no bond on probation violations.
So most people who are committing those kind of crimes don't have any money to go anywhere else anyway.
That's also true. It's not like we deal with a lot of international jewel thieves that have unlimited resources to go to international travel.
Or the well-heeled felons who are have their parents buy them minders. So, although that would be a bit, a minder. I'm sorry, that's British for having somebody that a minder is somebody that you just babysits you.
Oh.
All the time.
Okay.
All right. So, my right hand, Allen County Prosecutor. I just want to remind everybody that we're working very hard on this podcast. I write a lot of stories for your benefit that I want you to read because I love to write. And so we do have a dedicated Facebook page, which is called The Probable Cause. It's like the same thing as the podcast. Please go and like that. We also have a website. It's called www.theprobablecause.com, where the stories first get posted. Our podcast can be seen on YouTube, or you can listen to them on Apple and Spotify. And so we would just encourage you to do that and to let us cover things for you. So if you have an idea, you can always send us a message like, hey, why don't you guys cover this? I've had people tell me now, what you should really cover is this. So we're going to be doing some of that as long as Mike is agreeable to covering them. So anyway, from the podcast, The Probable Cause today, we are now ready to say goodbye. This episode is filmed and edited by Frosty Pictures. The Probable Cause is produced by Maumee Media.
Worried when I crossed the Michigan line, a cop from Steuben County waiting on I-69. A headlamp went out while he pulled me over, charged me with possession after I rolled down the window. Now that's skunk. Indians a trip when it comes to weed. It's like who doesn't smoke or use gummies? Your grandpa, your brother, your rich friend from school? Hell, throw in the whole courthouse and my attorney too. It's time those assholes change these stupid laws. It ain't worth the paper for a probable cause. Sitting on a bar stool in my usual place, this guy next to me said he was looking for some cocaine. Hell, I just sold him an 8-ball with a little piece off for me. But my buyer was a cop? Should've known he was a creep. So I'm a dealer, right? You gotta be kidding. It's a rich man's drug. I just take it because I'm injured. 8 years in Westville with a monkey on my back. There's more drugs in here than you can shake a shank at. One dirty drug test, man, this system's flawed. Undercover screwed me in my probable cause. Street crimes never did me no favors. I'm hooked on Fetty. I'm a junkie, not a felon. Told that son of a bitch on the way to lockup. I can't seem to shake it. I need help, not mocking. What do you want from someone who's been through the system? Drugs all through the house before mom and dad went to prison. Throw me in jail and give me a fine? Someday I'll be dead and away from your kind. Now I'm at the courthouse in front of a judge. Can't say my public defender cares for me much. Crimes are committed on both sides of the law. God help me now with this probable cause. C-shift never gets old. Anything can happen when you're out on patrol. You think I'm just eating donuts, man? Give me a break. Nothing on this job is a piece of cake. Lights and sirens activated. This knucklehead wants to chase. Baby mama at the scene just spit in my face. Wife's worried that someday I won't be pulling up at all. You'll read about my killer in a probable cause. Man. She went through my phone and she seen my text. I told her forget it. It was just my ex. She took a swing and knocked me flat. Man, I went wild and hit her back. Judge slapped me with a no contact order. Now she's got the kids and she's staying with her mother. So she started it all and I have to take the fall. You can read my whole story in the probable cause. When I was young, caught a case for dealing and did my time. Yeah, I got a record, but I was doing fine. Running my own business on the southeast side. Yeah, I got a gun. I kept it on hand. Told the cop my reason, thought he'd understand. In this neighborhood, you need some protection. Attorney thought I could get just community corrections, but the judge decided to send me to prison. Can't get ahead no matter how hard I try. Read the probable cause, it'll make you cry.
Whispers and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead. and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on Earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause.